I'm George Curtis. Welcome to It's Your Law. Each week it's my privilege to bring you this program. The key to the program are guests and subjects. We like to pick timely subjects and guests that have something to contribute that most of us wouldn't otherwise know. Actually, I had tentatively scheduled for this week's program some people from the Oshkosh Military Museum, and Roger had a knee surgery, so we're putting him off for a week or two so he can come in here under his own power. And I'm looking forward to that program because, boy, do they have plans for another wonderful Oshkosh Museum. But today we've got some home cooking of some real timely subjects involving people who are attorneys here at Curtis Law. Our first guest is attorney Mike Kuborn. Welcome to the show.
Thank you very much for having me.
Well, you and Beth Osowski had a seminar very recently involving some employment issues, and it was really well attended, wasn't it?
That's correct. We had nearly 50 people in attendance, and there was a wide range of questions, primarily within the employment law arena, most of which centered on discharges.
Well, I think that most of the time we're aware of the fact that our biggest asset is our ability to draw a paycheck. And as industries close down, get sold, jobs go across the pond to other countries, many people who thought they were secure because they were capable, productive, hard-working employees are finding out that there's no such thing as security, or is there?
Well, unfortunately, in most cases, there's not a lot of security, with some big exceptions, which can affect up to 20–25% of our workforce. And those exceptions would generally involve contracts, either a written contract with an individual, which you'll see in cases of professional positions, engineers, doctors, things of that sort, or, of course, collective bargaining agreements or union contracts. Those would be the exception to what's called in Wisconsin the at-will employment rule.
Now, what is that rule, at-will employment?
Unfortunately, if you're an at-will employee, your employer can terminate you for good cause, no cause, or for that matter, the wrong cause, and you have, in most instances, no recourse because you are at the will of the employer.
So an employer may have some economic reason, may think that the payroll should be cut, that profits are down, that wants a brother-in-law to come in. Any of those are legal reasons?
Unfortunately, if you fall in that at-will category, that would be correct. And in fact, just because the employer doesn't like you may be a sufficient reason, since there's not a requirement for cause in the first instance.
Well, I've always had the impression that you couldn't or shouldn't fire people who've been with you a long time, who are getting a little gray hair like you and I are getting, who disagree with you politically, go to a different place of worship and things like that. Are any of those protected?
Some of those are, and in particular, your last example, discharging a person because they have differences in place of worship, that would fall into one of the few areas that provide protection for those at-will employees, and that would be the arena of discrimination.
All right. So I'm getting the impression that we have to begin this analysis in terms of classes of employee, and the at-will employee doesn't have much protection. Am I correct?
That would be correct, with the exception of some more recent legislation, particularly the discrimination laws, different rules and regulations regarding retaliation for some things that employees are expected to do. There really are few protections for those at-will employees.
I see. Now, you say retaliation. Can you give an example?
I can give a couple of examples. A employee that complains to the state agency in charge of regulating hours and wages, as an example. A person that either on their behalf or the behalf of other employees complains about someone not being treated fairly in terms of overtime pay, not being treated fairly in terms of rights that employees have under, for instance, the Family Medical Leave Act, or in other words, being able to leave your job for different reasons and for different time periods. People who bring that to the attention of the state agencies that help to make sure that employers follow those regulations can't then be discharged for having brought that information to that state agency.
Is that what we refer to sometimes in street jargon as the whistleblower?
That would be correct.
So if you report to the IRS that I'm buying my shotgun shells through the office and putting it down as postage, I can't do a thing about it.
Well, and I'm not sure that that fits necessarily in one of the specific statutes that provide that benefit, but certainly if it were the stated reason for a discharge, it would at least be suspect.
All right. But there must be some laws that protect people, state or federal, I'm not sure, I'm going to pose the question, that protect people that aren't in that at-will employee category.
Well, people who are not in the at-will employee category are by definition covered by some kind of contract, either an individual contract or, as I mentioned, a collective bargaining agreement through a union. Those agreements will dictate the circumstances under which they can be terminated. So if the policies or procedures that are part of that agreement have not been followed, then those persons, that smaller group of employees, definitely have recourse in terms of a wrongful termination, since that would be outside that agreement.
Now, if we have an employment situation and an employee senses that they're not on as solid ground as they thought they were years earlier, because there may be a buyout, there has been a buyout, somebody else has been put in as supervisor, someone else seems to want a different team, the older people seem to be disappearing for various reasons. What do? Who do they consult?
The best recommendation would be to seek an attorney that does employment law work. If for nothing else, to determine what your rights would be under that circumstance before you have an actual termination that you need to deal with. We can assist with determining which of those categories we talked about an employee might fall into, whether there's additional information or conditions that are at play that may bring in some of the protections that even apply to those at-will employees.
So before you're fired is the time to get professional advice.
Most definitely. You're certainly under the gun and scrambling for employment if you've already been fired. So.
And Mike Kuborn, that's one of the reasons you were hired here. For the last 30 years, I have had many people call with an on-the-job concern about their job security, about unfairness, and then I look for somebody who will represent them. We have many able people here in the Valley who represent employers, but a real scarcity of people who represent employees, and that's why we added Mike Kuborn to the team. We're glad you're here, and thanks for being on the show.
Thank you.
What would you do if you saw something that was happening in the workplace that was wrong?
You know, we have a really good example in a plant here in Sioux City where they had their very first female lathe operator. And they had a foreman who wasn't quite ready yet to welcome females into the machine shop. And he just harassed this poor gal. He teased her. He called her names. He was constantly finding fault with what she was doing. And this one older worker noticed this, and he put up with it as long as he could. And finally one day he just had enough. And he turned the machine off, his machine off. He grabbed his notebook. He walked over to the foreman. He said, "I'm going to give you two choices. Number one is, well, I'm going to give you two choices. You leave that gal alone. You and I both have got daughters about that age, and you treat her as though you would want your daughters treated. Either that, or I'll take my notes and I'll go over to the office and I'll have them copy my notes, and I'll let them know what's going on, and then you'll be answering to somebody else. Or the second choice is that you guarantee me that you're going to leave her alone and treat her like everybody else and provide her with the support she needs to do this job. Those are your two choices." And the supervisor says, "Oh, geez, don't take it to the office." And he said, "Well, it's your decision to make." He said, "All right, I'll do my best to treat her like I do everybody else." And he said, "That's fine." He said, "Now I'm going to take these notes and I'm going to put them away in case I need them again someday." And it worked.
Right.
But
Right.
you know, they say to us that we are our brother's keeper, and in the workplace, I firmly believe that we kind of are responsible for what we see happening around.